Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Thanks, Brad. As a business and healthcare law firm, we are often immersed in the heavy details of a particular issue or project. It is beneficial, if not mandatory, to every so often take a step back and evaluate the bigger picture. This season's theme is Zoom Out. We have all been immersed in the life of a global pandemic, and so we're going to make sure with each story this season that we step back and look at how the issue we discussed will be impacted in our new normal.
Now, Michael, before we bring in today's, to get really in today's episode and bring in our special guest, I'd like to ask you, do you like college football?
Brad, I thought we had a deal that we were not going to ask any stupid questions on this podcast.
So I'm going to go with yes?
Yes.
All right. So who is your favorite college football team?
You did not just get my memo. I just said we all know that I'm a huge diehard UT Longhorn fan.
All right. Fair enough. And as a UT fan, let's go with, what was your favorite UT football moment?
Well, it has to be the USC games. I'm biased, but it is a fact that it's the greatest football game in college football history. And I have to say this confession, because this is one of those top 5 regrets that I will take with me to my grave, is that I had a ticket to go to that game, and I turned it down. And I turned it down for several reasons, all of them really bad reasons. You know, busyness at home, busyness at work, USC is going to be a big favorite. And so as much as I loved that game, I kept thinking about, what if I had actually been there? So much so that I did not hesitate to go just a few short years later when we were back in Pasadena and lost to Alabama in the next go-round.
Yeah. Well, as you know, I went to Texas Christian University. TCU was at the old Southwest Conference, where UT was also there, and a bunch of other Texas schools a whole while back.
Yeah, most of those schools are now in the Big 12.
Yeah, that's correct. So like you, I love watching college football. I grew up in New Orleans, as a lot of people know, and I was a huge LSU Tiger fan, except when the Tigers play the Horned Frogs. I always cheer for them. But one of my favorite college football moments, happened while I was attending TCU my sophomore year. TCU, back when I was there, was not a very good team. At this point in the season, we had won a game, tied a game, and lost basically 6 of those 5 in a row. And the 20th ranked team in the nation was visiting Fort Worth, Texas, to play my Longhorns, to play TCU, and that was your Longhorns. And in 1992, TCU beat Texas for the first time in 50-plus years, 23-14. We all charged the field. It was an awesome moment for TCU football. By the way, it was the first and only time I've ever charged a field, because I did get Billy Clubbed by a cop. But it was a cool moment for me for the TCU fans.
I kept thinking I was about to hear another Brad Streaker story, but
that never happened.
Okay, we'll move on. Well, we could probably talk sports and college football the rest of the day, but this podcast is not about sports. Well, except today's episode may actually sound like it. And I'm really excited because we are bringing in one of our buddies who has a great story to share. He's another attorney. His name is Mike Lyons. Mike is a founding partner of Lyons & Simmons. He is a old-fashioned trial attorney. You don't meet many courtroom lawyers anymore, and whenever we spend time with Mike, we get to hear just some fascinating stories of real, actual courtroom fights. He represents both plaintiffs and defendants. He has recovered hundreds of millions in judgments and settlements on behalf of his clients, successfully defended complex business and tort cases where his clients have been sued for hundreds of millions of dollars. Has all the trophies, super lawyers, top 100 attorneys in Dallas-Fort Worth, Law Dragon 500, leading plaintiffs consumer lawyers in 2020, D Magazine, and the list goes on and on. And one that is really cool is the Dallas CBS affiliate, Channel 11, recognized Mike as a Texan with character for his philanthropic work in the Dallas-Fort Worth Metroplex with children who were victims of abuse or neglect. Mike is as good of a human as he is a trial lawyer, and he's a great friend of ours. He's married to his wife, Jenny, have 3 amazing kids. And if you hadn't guessed by all the talk we've had, he is an even bigger UT fan than me. And so every year when UT and OU play, the Red River rivalry, we call it Texas OU if you went to UT, Mike hosts a really cool party at his house and has Bevo, the Longhorn mascot, among others, at the game. Mike, welcome.
Hey, it's good to be here. Thank you so much for the kind introduction, guys.
Well, Mike, as Byrd said, we're super pumped that you're with us today's episode. And, obviously we have known each other for almost a decade now. We first met through a mutual client. And as Byrd kind of alluded to, we think the world of you in general as a human being, but we always love hearing your stories about what's going on in the courtroom and how things are being moved around. So we're excited to have you today. And before we really get into today's story, we just love to understand what made you want to become an attorney.
Well, thanks again for the kind words. And I can tell you the feeling is mutual about you guys when I think about transactional lawyers and lawyers that have a particular emphasis on healthcare. You guys are at the very top of list, top of mind because of your extended experience and expertise. And so I'm really honored to be on your program. I'll tell you kind of a funny story and then answer it seriously. When I was a kid, my stepmother worked for one of the finest trial lawyers that you'll ever meet. And I spent weekends oftentimes up at the office when I was 7, 8, 9 years old, when she would have to go in and work. And initially what drew me into the practice of law, frankly, was the office supplies. I would show up to work with all the best highlighters and pens and pads and be like, man, I'm the coolest person on the planet. This practice of law seems pretty good. But in all seriousness, the thing that drew me in and continues to draw me in is the stories and the people and helping people in what could be their worst moment. As you guys know, my practice revolves around complex, catastrophic personal injury and wrongful death litigation, and also big business disputes. And those people have a common thread, which is they're all enveloped in probably one of the worst situations they've ever had to face. And so those stories and those issues are what continue to compel me to do my best as a lawyer, but also it keeps me interested every day to come into the office and try to solve my clients' problems.
That's great. And, we talk all the time about how, we love hearing your stories. And I think that's probably part of it is just they're so compelling. They're real stories of real pain that someone has experienced in some way. And just to hear, the thought and the strategy and frankly, the effort that goes into you fighting for those people is fascinating. I mean, we have had a common bond with you over the Dr. Death. I know we're on their podcast, and you were involved in that case for one of the victims, and us as healthcare attorneys were intimately familiar with that while it was happening in Dallas. And then more recently, I remember, checking the sports scores on ESPN in the morning and saw Mike Lyons show up on the headlines on ESPN. And so you've kind of moved in recent years into kind of a new area of protecting people, and that's in kind of the college football world, and would love to kind of hear how you got into that, starting, I guess, with Kansas, if I remember right.
Yeah, no, that's absolutely right. And so, I always I always have to tell people as a preface, because I don't want to get painted into a corner as being the guy who represents football coaches, but I really have become kind of the lawyer du jour. I don't know how long that's going to last for coaches. And in particular, when they have contractual disputes with the institutions. And so as the dollar value continues to raise on particularly major Power 5 NCAA football coaches is what we all see the most, but basketball certainly as well, the stakes get higher and things get nastier, and the need for trial lawyers to come in and help becomes even more important. And so that is kind of the backdrop. I mean, I handle cases that ultimately get filed, and sometimes they get tried involving people that have been aggrieved, and that could be people who have been killed or people who have been injured, but also big business disputes. So when I first was contacted about the David Beatty case, which you guys have alluded to, which was the University of Kansas owed David some money under his contract and very publicly decided they weren't going to pay him, to me, again, not to really diminish the work that's done by people who on a day in, day out basis, this is all they do. It felt more like checkers than chess to me to get involved in that dispute. And I'm making a little bit light of it because there was some complexity to it. But I was contacted in part because I know another head coach who I also represent, who is very close friends with David Beatty, and I won't say who it is because you both would know who it was if I said it. I was more than happy to talk to David, give him some advice, and ultimately he wanted to hire me after I tried to talk him out of hiring me. So that's when it happened, and now I represent somewhere at any given time between 3 and 10 different major NCAA coaches who have disputes, usually related to their contracts. A lot of them have remarkably similar facts. But the reason that I think David got into this jam that he was in was, part of it is perfectly obvious. He went 6-42 at Kansas, which I don't think is a reflection on David as a coach. I think it's a reflection on Kansas as a football team. They were a disastrous program when David took over in, I believe, 2015. And Charlie Weiss had laid waste to the football program. David was simply trying to bring it to the next level. He did that. He brought in some really talented kids that ultimately went on to the NFL and were successful. And as Kansas rounded third base on towards the end of David's contract, they brought in a new athletic director, and his name was Jeff Long. And I'll save the best for last on that. But Jeff Long ultimately decided that he was going to terminate David and go in a different direction. So that sort of kicks off how that dispute manifested.
Okay. Well, so, anyone who's ever picked up a paper before, or people like you, and I guess we've done these too, where we get these executive contracts where if they get terminated, there's some type of guarantee that's there, or some type of buyout that's there if there's some terms left. So since his contract sounds like he was terminated before it was over, what was owed to David?
Yeah, so historically, college coach contracts, in particular football coaches, have been guaranteed money, meaning that if you get fired because you went 1-9, they're going to have to pay you what the remaining term is on your contract, right? And that's usually discussed in terms of liquidated damages, right? So you've been terminated and now you're owed whatever remains on your contract. Now, we've seen that in executive compensation agreements for many years in the non-coaching ranks, like executive compensation agreements. This is not something new, but when they terminated David, my recollection is that he was owed about $3 million on his contract, which by modern times is really not that much money. I mean, $3 million is, it's not haircut money, so he wasn't willing to walk away from it. But some of these guys are owed tens of millions of dollars when they're terminated.
Wow. So talk about what happened. I mean, if it was, in modern terms, not a substantial amount of money, the contract seems clear that it's owed to him. What was the issue, and why did you have to get involved, and kind of talk about what you did?
Yeah, so this is where it gets more interesting. So David's terminated in November of 2018, and they told him they would like him to stay on. He's actually terminated in October. They had 3 remaining games of the season, and they asked him to stay on until the season was over. And they told him in the same breath that they were going to pay out the terms of his contract. So he did that. He performed. He finished the season, and when the clock hit 0-0 against the University of Texas and his Big 12 counterpart, Tom Herman, and the Texas Longhorns at the time, he knew he had to go back into the field house and clean out, his desk and office and move on with his life, which he did. About 2 weeks later, he receives a letter from the general counsel's office at Kansas, basically saying, hey, after you were terminated, and you were terminated without cause, it's important for me to point this out, they held a press conference, and they told the public, they told David, they told the team that he was being terminated without cause and that they were going to honor the remaining terms of his contract. That all changed. 2 weeks later, they sent him a letter saying, we've conducted an investigation, and upon talking to some people after you left, we believe some NCAA violations occurred. And as a consequence of that, under your contract, we are going to withhold payment, and we're going to see what happens with this investigation, and we may not pay you pending the result of that investigation. So away we went. And what enters is a trend that's existing now in college football and basketball, which is that if you've got a coach that you want to get rid of who maybe wasn't productive when he was there, and you want to avoid having to pay him the money, you can try to trigger one of these provisions that are in just about every coach's contract, which is either a morality clause or some type of rules violation clause, and say for some nebulous reason, we're terminating based upon that. And in this case, they did it retroactively. So they said, post termination, we're going to fire you with cause based upon the belief that you may have committed a violation. So that's when I get hired. And of course, there's a parallel proceeding involving the NCAA. The part that still perplexes me and I still sort of chuckle about is why a school or any institution like the University of Kansas, who at the time, so your viewers or your listeners may not realize this, but in October of 18, Kansas was embroiled in a terrible, and still is, a terrible NCAA investigation involving a number of athletes who allegedly received payments, illegal payments, from a number of different Adidas shoe representatives.
Oh, yeah.
And it's a little known dirty secret that some programs have utilized their sponsored sports merchandising company, in this case Adidas, to sort of back channel and recruit. And there's a whole lot of things swirling around. We could spend a whole day on that, which I won't. But in October of 18, 2 gentlemen, a guy named TJ Gasnola and a guy named James Gatto, were tried alongside some other shoe representatives in a federal corruption trial in the Southern District of New York, and they were convicted. They were convicted of wire fraud, of allegedly sending payments through the wires to these players and to conspiring to do so in violation of federal law. So what happens in October of 18 is Gasnola turns state's evidence for the United States attorney, testifies against his co-conspirator, and ultimately they get a conviction. Now that becomes relevant in a little while. I won't jump to the conclusion, but I'll tell you that one of the things that we did with Kansas very early on was we told them, are you sure you want to kick over this anthill? Because if you're telling me that you believe David Beatty committed NCAA violations, which he did not, and you're going to base that as a reason to terminate him post non-causal or without cause termination and try to change the characterization, then you better hope your house is in order, because we're going to go look through every other circumstance involving every other coach to see how you handled that. And in particular, your star, who is their current basketball coach still, Bill Self, who was at the center of that controversy. So this sort of led to a philosophical standoff. Kansas on the one hand saying, no, really, we're not going to pay you. And me telling them, really? Okay, are you sure that's what you want to do? And that coalesces in March of 2019. I filed a lawsuit, which, anybody can go Google. It was front and center headline news on every major sports reporting network about the fact that we had uncovered evidence that that the athletic director, then Jeff Long, was openly telling people while David was the head coach and after that he was, quote, looking for a dead hooker in a closet so that he could terminate David for cause.
Wow.
When he didn't locate that, he then ginned up alleged rule violations. And the way he did that was he had these meetings with various quarterbacks that he claimed had received improper coaching from a consultant or a non-accountable coach. And I guess this requires me to tell you a little about NCAA rules because it's relevant. Under NCAA rules, you can only have 10 countable coaches. Those are coaches that can actually give instruction to a student athlete, and instruction being tactical football instruction. If you're a non-countable coach, like a technologist who handles the video, or these analysts that you always hear programs hiring, which are usually ex-coaches, they're not supposed to coach the players. And so what they were alleging was that David Beatty was using a non-countable coach to coach up the quarterbacks, which was a bunch of malarkey, as it turns out. But ironically, if you were to look at every single football program across the country that employs non-countable coaches, what you would find is evidence that it's fairly widespread that those people are misused under NCAA rules. I'm not saying that happened at Kansas. In fact, on the contrary, but that's sort of teeing up what the dispute was about. And we said, here's the deal, and this is actually relevant for your listeners. If you're going to change somebody's termination, whether it's an executive compensation agreement or a head coach, you want to change the characterization of their termination post-termination. It triggers a body of case law. There's a case called McKinnon from the United States Supreme Court that says there's 3 elements of what you have to prove if you're going to do that. Number one, you have to show that this was a prohibited action or conduct on the part. If any employee had done this, this would be grounds for termination. Number 2, that this particular employee engaged in that behavior or conduct. And then number 3, you have to show causation. In other words, had you known about this before you terminated them, you would have terminated them for cause. Okay. Yeah. Well, this opens all sorts of trapdoors. And what it leads to is discoverability of other incidents, other circumstances where, an employee has engaged in unlawful or improper conduct. Well, applying this back to Kansas, their basketball coach was at the head of a massive, and still is, massive NCAA rules violation investigation. And they never suspended him, never fired him, obviously, never withheld pay. So this became a major fact question.
Wow, that's amazing. I want to hear what you did to get Kansas's attention. So Let's take a quick commercial break, and when we come back, we can talk some more about this and get your perspective as a trial attorney and hear what happened with Coach David Beatty and his lawsuit with Kansas.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd, and we're still here with our special guest, friend, and trial advocate, Mike Lyons.
Yeah, man. And Mike, I want to hear, kind of picking up where we left off. What did you do to get Kansas's attention?
Yeah, that's a good question. So 3 things, and the first thing is that we compelled them to produce all of the communications by and between them and the NCAA regarding the basketball violations, which they didn't want to give us. We ended up having to get a court order to get all that information, and we did. And so they really didn't want anybody outside of Kansas knowing about that. We got it. The second thing is we took the deposition of the athletic director and other people under the athletic director. To my knowledge, it's the only time that a major Power 5 athletic director has had to give a sworn deposition in civil litigation ever. In fact, many people said, you'll never be able to do that. They'll never let you do it. They'll settle the case before it happens. Well, it happened. And the deposition then became public. It's publicly available. And it was quite embarrassing both for the then athletic director and ultimately the institution. And then the third thing we did was I said, when I took the athletic director's deposition, I got him to say over and over again how terrible these alleged violations were against David, that he had allegedly, through another staff member, provided improper instruction to his student athletes. And I got him to say that was, grounds for termination for cause. And then I went and demonstrated that the current head football coach, a guy named Les Miles, who, Brad, since you're an LSU fan, you may remember Les.
Yes, I do.
Les replaced David at Kansas, and I rolled back. I hired a former staff member for an NCAA committee on infractions to review all the game tapes for the entire season during Les Miles' initial season. And I found about 45 instances of non-countable coaches providing tactical football instruction to student athletes in plain view on the broadcast. I also found analysts that were providing in-game strategy to Les Miles directly, again, in full view on camera, which is also an NCAA violation. And then I showed that to the athletic director, and it was quite compelling. So that got their attention. And then I guess there was a fourth thing. I subpoenaed these Adidas guys for deposition, which became public. And Kansas was not about to allow me to go connect the dots back to their basketball coach. And so they ultimately relented and resolved the case.
Well, before we get to the result of that case, let's, this season's theme is zooming out, Mike. And, if buyouts and guarantees are the rage now for all these professional and college contracts, and even as you mentioned with executive agreements, what are some of the pitfalls that employers are starting to use in these contracts to help nullify these sections?
That is a great question. And I don't care if you're the head coach at the University of Alabama or you are an executive for a publicly traded company that is a big healthcare institution. You need to be worried about anything in your contract where you've got guaranteed comp or a guaranteed term that is squishy or gray on what constitutes misconduct. Here's how it comes up for coaches. if you violate an NCAA rule, or anybody within your supervisory role as a head coach violates a rule, then you can be terminated for cause. Well, that's tricky for coaches, because under NCAA bylaw, I believe it's 13.1, you're effectively vicariously liable for the conduct of your subordinate. So if a subordinate without your knowledge violates a rule, you are presumptively responsible for it. So they can virtually trump up whatever they want, terminate you for cause. Now you're in a vortex trying to get your money back. I'll tell you how it comes up. If you're an officer or director for a publicly traded company, it comes up a lot of times with morality clauses. We see them in college football, but something along the lines of anything that would bring public embarrassment to the institution. And the things that we commonly see are things like, well, this guy got a ticket for jaywalking, or this guy had an affair on his wife, or this guy got caught with, a misdemeanor amount of marijuana on vacation, or whatever. Anything like that that's in your contract may trigger a trap door where you have an out. And so when I'm advising clients and lawyers like yourselves that have these kind of clients, is to take a look at those provisions and to redline the heck out of them so that they're favorable to your client. There's a second thing. The other thing I would think about doing is I would contract away this whole after acquired evidence doctrine. I mentioned the McKinnon case. I would put right there in the contract that, your decision to terminate is final, and you do not have the ability to change the characterization of the termination based upon after acquired evidence. And I would contract that away. Those are a couple of examples of things I would think about doing, Brad.
Wow. And you mentioned a couple of times, you brought in what was happening with Bill Self, you brought in what was happening with Les Miles, and talk just a little bit about how the importance of how an employer treats other employees to, kind of a current situation, like in this example.
No, that's a great question, Michael. That's called disparate treatment. And what it goes to in the case of an after acquired evidence case, it's material because it goes to whether or not under that third prong in McKinnon, you can show that you would have terminated based upon the alleged conduct. So it's relevant in that regard, both in discovery, but also in challenging that element. The other thing is just a good old, back in law school, we learned about, material breach. Like you have to establish that the breach was material. Mm-hmm. Well, one of the things I think you can always attack if you can show, hey, this other employee over here, or this other, the volleyball coach is out there violating the rules and you knew that and you didn't do anything about it. Or this person engaged in conduct that was embarrassing to the institution and you didn't do anything about it. That would be an example of clearly you didn't think that was material, so why is this material?
Right.
So either way, it makes it discoverable. You can put pressure on the other side, but from strictly from a tactical standpoint, that's why that stuff is important.
Yeah, and I think 2 points to take away from that, which are important for anyone who's hearing this, is if you are the employer and you know something bad is happening and you're not doing anything, you're not doing anything about it, and you terminate someone for a lesser cause, that you as the employer can get in trouble down the road if you try to enforce a non-compete or non-solicitation, because they say, hey, you did something, they violated something already and you did nothing about it. But, Mike, we're kind of winding down as far as the time that we have left today. And again, we're super appreciative that you could be with us. But for our audience, you kind of already noted that you put Kansas in a pretty bad position, and they're ready to figure out what to do with you. So I believe in the beginning you might have mentioned there was about $3 million that was owed. So what ended up happening?
Yeah, so what happened was I told the University of Kansas that if they went down this road that people were going to get fired, and I told the athletic director that. So what ultimately happens is this. They paid David $2.55 million instead of the full $3 million. And the reason that David was willing to accept that was because under Kansas law, you can't recover attorney's fees. So I told David, I said, that's a better than result if you go to trial. You can get the full $3 million, but it's going to cost you $500,000 to get there. Mm-hmm. So he gets the $2.55 million. Perhaps the sweetest part of the whole deal is a lot of these people got fired. Jeff Long, the athletic director, fired. He's no longer, I don't know that we'll see him again in college athletics, and in large part because of his mismanagement and blundering idiocracy over how this was handled. And then, maybe the sweetest part of the whole deal is that ultimately the NCAA determined, the IARP, which is a division that the NCAA hands off complex cases to, who is ultimately going to decide the fate of the basketball program, they took a look at what was done here with David Beatty, and they amended the notice of allegation to dismiss all those claims. And to my knowledge, it's the only time in the history of NCAA sports where a coach has challenged a coach control violation successfully. So awesome. All of those things have happened here. I would say David Beatty can call scoreboard on all of this, and he deserves it. He's not only a fantastic coach, but he's a fantastic man. That's great.
Well, we're going to zoom out here for a brief second, and throughout this theme, and you've given us a lot of things for our audience to listen to, and so as we take a big step back, a big zoom out on it from a trial lawyer's perspective, when you look into the future here, what's happening now with these guaranteed contracts and termination provisions? What do you see?
Well, I think what it is that your antenna should automatically go up because they're being used as a device to basically sidestep the intent of the parties in the contract. Mm-hmm. It is a way to drive a wedge between any opportunity for a person under a contract who thinks that they're going to get the full measure of their term under a liquidated damages provision. It's an opportunity for the employer or the institution to basically sidestep their obligations, buy time. What I see more often than not is these schools don't have the intestinal fortitude to see it through, but they use it as a bargaining chip. And so if you want to avoid that, you got to take the squishiness out of the contract, because that's where it's headed.
Yeah, good points. Michael, I'll give you some final thoughts here as we zoom out. What do you see?
Yeah, I mean, I think you can extrapolate this to other executive contracts, and Mike's done that a few times today. And I find even in sophisticated contracts that there's a human nature of particularly the employee side not wanting to engage in these kind of awkward discussions about termination provisions and kind of the what ifs. Things go bad. They find it awkward. And this is just an illustration of where the stakes can be significant if you don't deal with it, and you can mitigate a lot of risk if you, using Mike's words, take the squishiness out of the contract.
Yeah, I totally agree. And Mike, you said a great point, and actually both Michaels, Michael squared here, that they think they're getting this great deal because they think they got guaranteed money no matter what. And if there's some squishiness in there, they're going to use that against you and hold up money, and you're going to have to go to get someone to go to court for you and fight to get it. And that's never the best spot. And in this case, it was worth it. But, we've talked about this in other episodes. Sometimes it's not worth it when it's the smaller dollar amount. But, Lyons, thank you again so much for joining us today. We always appreciate spending time with you, no matter where that finds us. And in our case, we've been lucky and blessed to be with you in multiple different places over our lifetime. But thanks again for being here, Mike.
Boys, it's a pleasure. I'd love to come back anytime. Thank you so much.
Well, thanks again. And, this is all the time we have today. Join us next Wednesday, which is going to be our last episode of Season 5. We will have the owner, the COO, and founder of VO Franchise Group, Randy Stepp. He'll join us to discuss developing a compliant med spa franchise in multiple states. Thanks again for joining us today. And remember, if you like this episode, please subscribe, make sure to give us a 5-star rating, and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.